Hi everyone. In today's video, I would like to talk about premarital agreements, not about validity when it's regarding surrounding circumstances such as 7 days, having a lawyer, having financial disclosures. I have enough videos about that. I'm going to link them down in the description box below. Right now, I would like to talk about prenuptial agreements when I am a reviewing attorney. What am I looking for? This week, I have two prenuptial agreements, and I'm representing future spouses, obviously, before the marriage. And the reason I'm the reviewing attorney because my client, and it's typically the case, has less money, and the high earner, high net worth client is the drafting party, and they have an attorney. And then I get about a week or two to review this, and here's what I'm looking into. So let's start with a case where a high earner is sponsoring the lower earner spouse into United States. It's going to be K1 visa. He's going to be signing Affidavit of Support, or she. It doesn't matter. Let's say the drafting spouse and the reviewing spouse. So I'm representing reviewing spouse. In this case, the first page is usually describing when are they getting married, all the statistical facts, and that includes the age, if they were married before, where are they working, and what are the circumstances upon which they're getting married. For example, he resides in America, she resides in another country, and the boilerplate of this prenuptial agreement is regarding just the facts, how they file taxes and things like that. So I'm going to focus on things that I think are important, because if you're the type who is receiving this reviewing piece and is curious what this all means, I can go through it because most agreements have a lot of the same type of language. And then when it's not the same, I'm going to speak about that as well. So Uniform Premarital Agreement Act, this portion describes Family Code Section 1600 through 1617. This is the code section where it describes that there are 5 things in order for the prenuptial agreement to be valid that I already addressed in a different video. Just a highlight. If the prenuptial agreement doesn't have disclosures, that's not valid. If the spousal support waiver is in the prenuptial agreement and the spouse who is actually asking to get spousal support regardless of the waiver, and that spouse was not represented, so usually it's reviewing spouse, then of course there is a code section in the 1600, 1611, I think, or is it now 12, where it says the spousal support section is not going to be valid if the reviewing party was not represented by an independent family law attorney. It doesn't say family, but it's another layer of protection that you would like to have. So independent attorney is official language, but independent family attorney is the language that you would like to have, because if you don't have a family law attorney, then the reviewing spouse could argue, well, my criminal attorney didn't know family laws. I didn't know what I was signing. So financial disclosures. Right now, you don't have fiduciary duty before you get married, but once you get married, you have fiduciary duty to disclose everything. So what's the difference? It's prenup, postnup. In the prenup, you can estimate to the best of your abilities what is the value for everything you're disclosing. For example, if you have a home, you can go on Zillow. You don't have to get an appraiser. If you're married, then the marital settlement agreement potentially could be set aside if you didn't have an appraiser and completely miscalculated the value. Then it goes to describe that there is no rights and duties arising out of the premarital relationship. Usually it addresses the Marvin claim. What is Marvin claim? Marvin claim was based on a case from 1971 from California Court of Appeal, where a not married man said to his girlfriend, they run business together, they have 3 kids together, oh, don't worry, I will give you half of everything, I will pay you support and all of that. And the community thought they're husband and wife, and she worked for free for the business he operated. And then once they separated, he's like, we're not married, we don't owe each other anything. And the court said, wait a second, that's not how that was supposed to be. And that case was a big freak for California law, because we don't have common law marriage where support and division comes into play when they're not married, but that was an exception. So there are not many Martin cases in 13 years. I personally never had a Martin case, and I know there are only 3 experts who specialize on Marvin cases, and they're very rare. But it always comes since that 1971 that any oral agreements become invalid with this premarital agreement. Then it goes to say how the earnings during the marriage are going to be. Usually, under community property law, everything is community. Why do we do prenups? We don't want it to be community most of the time. So this section, 2 pages long, describes that earning during the marriage is not community. It's separate property of the person who is earning it. And then property acquired during the marriage becomes the title trumps. And so if the title is in one person's name, that it's their separate property. If it's in both names, if they buy joint real estate or anything else, then it's community property. But then whoever puts separate property money to buy it has the right dollar for dollar to reimburse him or herself. So that describes that. Joint expenses. Joint expenses is a section where most couples say, in order to have joint expenses, we have a joint account. And then we put either 50-50 or proportionally to the income to contribute to this joint account, which means it's a community property account, and we're not going to do reimbursement to separate properties. So if we separate, we just split it 50-50. This is to make life easier. Another section I add to this joint expenses section is to say that if one spouse accidentally transferred a lot of money into the joint account, then they can transfer it back within 30 days. If it was a mistake, then they need to fix it within 30 days. If they didn't do it, then it wasn't a mistake, then it becomes community. Property consideration, reimbursement rights, general known, unknown, reimbursement of separate property. So these sections are more about if someone puts separate property into community, then they get dollar for dollar reimbursement. If community puts into separate property, then community gets dollar for dollar reimbursement. And people can decide whether it's dollar for dollar, or if they invested, for example, community invested into separate property stock, and stock was rocketing, whether the community has, or separate property, whoever invested gets reimbursement dollar for dollar, or with the increased value. This is the part where it's kind of hard to predict what's going to happen. That's why it's more dollar for dollar, unless agreement made otherwise. Spousal support waivers. This is the favorite part of this agreement because there are basically 2 things that are important in one agreement. Financial disclosure aside, is how they're going to treat assets and debt and income, and how they're going to treat spousal support. Those are the 2 main things I'm looking in the prenup. So I don't like spousal support waivers because of many cases of appeal that declare them unenforceable or unconscionable at the time of the enforcement of the agreement. So in this agreement, it says a waiver. However, the lower earner gets $17,000 each year for the marriage. So if they're married for 2 years, then the lower earner gets $17,000. So for each year from the marriage, one party pays the other party spousal support based on the amount of years. So if basically every year the lower earner earns that amount of money that is going to be paid after. In these cases, I like to put the deadline when it's supposed to be paid. So I have notes. Does it have an adjustment of inflation? Is it going to be paid the full amount within a certain amount of time, within 30 days from when one party files for divorce? Because in this agreement, it didn't have a deadline, which means the higher earner can say, yeah, I can pay you once you sign all of this paper saying this agreement is valid and the divorce and you move out. And basically the high earner has a lot of leverage to pay because there is no deadline. So I fixed that. I also suggested to increase the amount based on the amount of years the parties were married. So after 7 years or 5 years, to increase from 17 to 27 or something like that. But that's up to the client to decide. Now, let's talk about sponsorship and green card sponsorship. When a sponsoring spouse sponsors, then he or she signs an affidavit of support, a Form I-864, that states until, and there are a bunch of conditions, one of them the supporting spouse has to pay 125% above minimum poverty level of that state to the other spouse. And there was a Kumar case of appeal, saying that this affidavit of support is a contract. So we have prenuptial agreement, which is California level, and then we have sponsoring another spouse for the green card is a federal. So federal trumps state in this scenario because affidavit of support is a contract. So how do we deal about this in the prenup? I suggest in all prenups where there's a green card situation to add a minimum amount based on Kumar. So the poverty level, annual poverty level in San Francisco is $15,060 a year. 125% of that is $18,825. Now, my client doesn't want to increase that amount, but if divorce would happen and God forbid the client was disabled and needed the money, then the reviewing spouse and the spouse who needs the support could enforce, independent of this prenup, Kumar case. And the court would grant it because case of appeal said, Kumar, you have to pay 125% above poverty level until that spouse gets an American citizenship or remarries. And in Kumar case, the court said the lower earner does not have to mitigate the damage, which means the lower earner does not have to seek work. It goes beyond principles in family law where when spouses have a child, then they need to be self-supporting, they need to find job, they need to seek employment. Kumar case was shaky. So I would add Kumar right here. But again, client is the boss. This goes to say protective language is that they signed it under no duress, voluntarily, basically copying a lot of language from the spousal support waiver code sections to make sure that it's enforceable, but I don't think it will be. Inheritance. Usually prenups don't have inheritance section. We only say you can do your own inheritance by hiring a estate planning attorney, and you can do whatever you want with your will and trust. However, if they have a real estate, I had a situation when in 1 month, 2 women came to me crying because they had an agreement with a different attorney who helped them to review it, where the other spouse who passed away was the sole owner of the real estate that they both resided. And so the moment the spouse passed away, the heirs came in and kicked these wives out. It was like literally 2 women, same month. And both of them were crying because if a lawyer had a provision to say, well, let's create a joint tenancy with right of survivorship. Let's create a section that says if something happens to the other spouse, it can be done in this agreement or ideally in a trust agreement, that if the other spouse dies, then the remaining spouse in the home can stay X amount of years, X amount of months, basically some type of provision that could be enforced against the heirs. And especially when couples have children and someone wants to protect their real estate, I suggest to have a really good trust agreement if it's not done in this prenuptial agreement. And then the rest is more about properties, how it's handled, and this is not that interesting. So gifts between spouses. Here it says if gift is above $10,000, it requires something in writing. And I was thinking about it, if someone makes, I don't know, if someone has $2 million in revenue and they make $500,000 a year and they give their spouse $15,000 watch, will that spouse say, hold on, 10,000, so it's more, let's actually have something in writing? Nobody's going to do it. So I propose to add a section that says nothing in writing is required if the item given is for personal use, and specify what it is: watches, rings, bikes, things that you wear that are jewelry pieces. But again, client needs to think about this. Estate planning, dispute resolution, saving clause, severability clause. What is severability clause? It's a clause that says if any of the section is not enforceable, the whole agreement is enforceable. And then finally, it says prevailing party. So if someone starts to challenge this agreement in court, then most agreements say that prevailing party gets the attorney's fees. So it's de-incentivized the spouse who wants to negotiate a better deal at the divorce. Think about it twice, because then it can become, give me my attorney's fees. And if the higher earner hires an expensive attorney, it can become really quickly really expensive. Then it describes legal independent counsel. And then what I suggest at the end, we have Exhibit A, Exhibit B, then we have attorney certification where each attorney signs. And then both parties go to the notary and notarize this agreement, send it to us, attorneys, we sign. And then we have a copy, because if the client loses a copy, we keep it. I have it. All right. I hope that was helpful. Click like, subscribe, and I will see you in my next consultation. Bye.